I would, Your Honor.
All right, we can call Shoneth v. Secretary of State. It's file 26-9208AL. Counsel, you want to state your appearances beginning with petition?
Luke Custody on behalf of the petitioner, Your Honor.
Mr. Goodrich on behalf of the Secretary of State.
All right, and this is an appeal in a driver's license matter, and I've had an opportunity to review the petition for review, the record below, as well as your brief in support of the petition. Mr. Kukuski, go ahead and make any argument you wish.
Thank you, Your Honor. Mr. Shoneth appeared before the Secretary of State seeking to have his restrictions removed that he had on his driver's license. Basically, the restriction, it was a curfew restriction that he had left on his driver's license. He had been revoked back in 2004. The restrictions that he received after the revocation, the year of revocation, were that he had the interlock in for a year, and then the, I guess, restrictions that associated with that. After a year of successful interlock, he did have that removed by the Secretary of State. He continued on the restrictions until the hearing he recently had to get those removed. At the hearing, the hearing officer found that not only was she going to keep on the restriction, but she was re-revoking his driver's license at that time. And so we're here to appeal that decision and ask the court for a granting of his full license. The hearing officer made a few different findings to Mr. Shoneth to support, I guess, her reasoning why he should be back on the revocation. One was the interlock. She claimed there's no interlock report filed. When I did see an email that he had sent that should have made it into the record, why it wasn't, I'm not sure. I know that's not part of the record for Your Honor to decide, but her order in and of itself on the first page indicates that he was successful on the interlock. That's why it was removed. If you're not successful, that restriction is not going to be removed from you. And so, or
his revocation would have been reinstated.
It certainly would have, Your Honor. So I think that argument is without much merit. And certainly is to me an abuse of discretion. And then she went on to take issue with the statement that he made during the hearing, which asked about his sobriety. He says, working towards not drinking again. And so, in my experience with recovering alcoholics and dealing with the AA community, and I'm sure Your Honor is familiar as well, it's a lifelong process. It's a lifelong commitment. And so they don't talk as to, I'm never going to drink again. They say, that's my goal. And I think even later in the hearing and in my brief, I put a statement that he had said that, I hope not to drink the rest of my life. And that's my goal. And that's what I'm hoping to maintain my sobriety. So again, I think that was a misplaced reason to revoke him again. There was.
All right, guys. Today we're stepping into a courtroom case that takes an unexpected turn. A driver who successfully completed years of restrictions returns to request a full license, believing the hardest part is already behind him. But instead of removing the final restriction, the hearing officer revokes his license all over again. His attorney immediately challenges the decision, arguing that missing records, misunderstood statements, and flawed reasoning have completely changed the outcome. As the arguments unfold, it's clear this case is far more complicated than it first appears.
So testimony as to marijuana use. He did have and testified that he had a medical marijuana card. It was prescribed to him. He was honest about his use. His last use was back in July of 24. That was disclosed to the assessing agent who chose not to give any, status to his marijuana use. And so, again, it was a prescription that he had when the medical marijuana cards were. He didn't renew that prescription when it became legal. It was basically an over-the-counter prescription at that point where his doctors, well, you can get it, you can get it. He no longer uses marijuana, and he doesn't have any intention to use marijuana. But certainly, I think that was, again, an abuse of the discretion by the hearing officer. And the final and last thing was the drug screens. The hearing officer indicated that his drug screen had no variables on the drug screen And in fact, if the court looks at the record that was provided with the transcript, Mr. Schoeneck did provide 2 drug screens. One, he provided, they emailed him right back and said, well, this doesn't look like it might meet the muster of the standards for the hearing officer. So he went and retested. Both tested negative for any substances, but the second one certainly did provide variables and would confirm that he was not using any drugs or alcohol because of the negative test that he received. Given his testimony, given the drug screens, his assessment, and just the totality of the information, and that he was there to remove the restrictions. He wasn't there as trying to get just a license or on restrictions. I do feel that the decision by the Secretary of State to reinstate his revocation was not supported by the substantial evidence on their whole record. It was just clearly an unwarranted abuse of the discretion of the hearing officer. So we're here today to ask the court to overturn that decision and to grant him a full license. Thank you.
Okay, thank you. Ms. Goodrich, the Secretary's position?
Oh, Your Honor, I'd ask that you find that there is not an abuse of discretion for the reasons given by the hearing officer in denying the request. One was for violating the restriction by using marijuana as recently as 2024. He did not have a marijuana card at that time. He also testified that he had been sober for 20-some years. Both of those things can't be true if he is using marijuana without a prescription. He also was not following, the second reason was that he was not following the recommendations of the substance abuse.
Buckle up, guys, because this is where the evidence starts taking center stage. The attorney carefully explains a driver's past medical marijuana use, negative drug tests, and years of sobriety, insisting that every concern raised by the hearing officer has already been answered with solid proof. But just as that argument seems convincing, the Secretary of State pushes back with an entirely different interpretation, claiming multiple violations and failures to follow recovery recommendations. Now the courtroom is left with 2 completely different versions of the same facts.
Well, thank you. Well, this court's review is, of course, for an appellate review. Not what I would have done, but did the Secretary of State hearing officer make a decision that was supported by competent material evidence on the whole record? Or was the decision arbitrary, capricious, or an abuse of discretion? And in this case, the petitioner had a revoked license for a couple of drunk drivings a long time ago and got a restricted license that at that time only had a 1-year interlock, successfully completed that interlock, and then was driving with the restriction for like 20 years. And then finally decides, I want to get rid of all restrictions, and goes to the Secretary of State to do that. He had the burden of proving by clear and convincing evidence that his substance abuse problems are under control and likely to remain under control. He presented evidence that he had abstained from alcohol for over 2 decades, supported by his community letters, submitted a substance abuse evaluation with a positive prognosis in not 1 but 2 drug screens. One of them looks like it was an instant screen at a doctor's office. And then the second one was a lab report through Redwood Toxicology, which is the same lab that this court uses as part of its treatment court supervision. And the petitioner disclosed to the hearing officer that he had a one-time, he had a use of marijuana in 2024. He didn't.
All right, guys, now the judge takes control of the courtroom and begins examining the entire record instead of relying on assumptions. He carefully reviews the driver's history, decades of alcohol abstinence, community support evaluations, and drug testing before addressing the biggest concern, an isolated marijuana use from 2024. Rather than jumping to conclusions, the judge starts questioning whether that single incident is really enough to outweigh more than 20 years of documented sobriety, shifting the momentum of the case in an unexpected direction.
Isolated use overcomes the strong evidence of 20 plus years of alcohol sobriety. Further, the hearing officer found fault for the petitioner not submitting the interlock report. But the interlock report was from 20 years previous. The hearing officer would, I think it certainly is. If the hearing officer didn't have access to the report, the hearing officer could have easily obtained access to that report if there was any concerns, or could have continued the hearing to allow Mr. Shona to provide it. Where the interlock was removed 20 years ago, and there's a notation on the record here that the hearing officer said there were no violations. And of course there weren't, or it would have been extended, or the revocation would have been reinstated. So that's sort of an abuse of discretion to say, I'm going to fault you for not giving me the 20-year-old report when everybody knows there would have been no violations, or you wouldn't be in the situation you're in. And plus, as a hearing officer, I can get access to it, or at a minimum, I could continue the hearing if I want to review it to give you a chance to get it for me. Didn't continue the hearing, didn't even continue the restrictions. Oh, and then also the hearing officer found fault with the drug test because it was only an instant screen. Well, the hearing officer is just mistaken about the record. There were two tests. One of them was just a screen, but the other one that's attached to the official record on appeal does have a lab report. And for the hearing officer to say, well, you didn't give me a verified lab report, that's just contradicted by the record. So based on this record, I would find that the hearing officer's decision reinstating the revoked license for Mr. Shona was an abuse of discretion.
Buckle up, guys, because this final stretch completely changes the outcome. The judge openly points out mistakes in the hearing officer's reasoning, explaining that missing interlock records from 20 years ago could have been obtained easily, and that the laboratory drug report was already part of the official record. After reviewing every issue, he concludes the revocation wasn't supported by the evidence and orders full driving privileges to be restored. If you enjoyed this courtroom breakdown, don't forget to like the video, subscribe to the channel, and turn on notifications so you never miss our next case. Thanks for watching, and we'll see you in the next video.